Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Thank you for joining my YouTube channel. If you become a member, I appreciate it. It helps us all. Or this is my private Facebook group, and you can certainly join us here if you want to help each other with foreclosure related matters. And that's what we do. So today we're going to talk about something very important that I think everyone should think about if you're fighting the bank, either as defendant in a judicial foreclosure or as plaintiff in a quiet title action, state and federal. These are both very important, and this is about local rules. So let's get started on local rules. Rules of the game, why local rules matter. For instance, the CPLR, which is in New York, it tells you what you can do, but the local rules tell you how and when you must do it. So let's look at the state first. Many pro se litigants do know the law, have good defenses, but they still lose because they missed a local rule. What are local rules in foreclosure cases? Foreclosure cases are governed by 3 layers. Number 1, and this is New York for an example. The CPLR governs motions, service, pleadings, and appeals. Layer 2, uniform rules, or 22 NYCRR, motion practice, form requirements, settlement conferences, and foreclosure-specific procedures. And Layer 3, which is the county and judges rules, and this is where people struggle, motion calendars, return dates, RJI requirements. Deadlines for oppositions and replies, whether hearings are automatic or paper only. So let's stop for a minute and look at that, because a lot of people get confused when they file a motion and there's a return date and there's a hearing, and what we mean by paper only. Okay, so here is an example, and this is in the New York State Unified Court Systems Web Civil Supreme website, and you can see the web address right here. Just pop in a case number and take a look. We're going to use this as an example. Okay, so here's the case as it comes up, and it's in Dutchess Supreme Court. This is a foreclosure case, Nation Star Mortgage. It has Logs Legal as the attorneys for the bank. Let's take a look at this. Okay, so the next window comes up, and you can scroll down under where it says show appearances. Now I know that Tony filed a motion to dismiss against the bank, and you can see the appearance date on here is 2/23/26, and you can see this is a motion to dismiss, and that's the appearance date. And you can see right here it says administrative, no appearance required, which means he does not have to appear in court for those. And the judge will definitely just decide things on the papers that were submitted. So this is something a lot of people get confused with when they think that there's going to be a hearing date and it's there, but they don't have to actually physically appear. Again, that's one of the local rules. Now, where do you find the local rules if you're in New York? Well, if you go to the NYCEF, right here, NYSCEF, which stands for New York State Courts Electronic Filing, main page where you do the case search, over on the left, you'll see where it says Rules and Legislation. You see, right here. So you just want to click on that, and it brings up everything. And again, these are broken down per section, so you can look at what you need to look at. The trial courts, for instance. Everything you can imagine is in here, guys. And I know it's boring reading, but you really need to read through this if you're in state court and you're fighting your foreclosure. It's just important that you know the rules. Okay, so what if you're in federal court? Let's use the Middle District of Florida as an example. Go to the main home page. You can see local rules right here. And you can click right there on local rules. And here they come. You can also download a PDF of the local rules right here. Let's see what they look like. Okay, here's the local rules. And you can see they were updated on November 1st, 2025. And you can see the contents here. Administration. Here's the layers. And then your Chapter 3, which most of you need to read if you're fighting in federal court. Motions, briefs, and other legal memorandums, civil case management. All these things are very important. We'll go through a few things with the federal court as well, just so you know. These are very important if you're fighting in federal court, what you need to know. So let's go over some of that too. It is important to keep in mind that federal court is not more forgiving to pro se litigants. It is more rule driven. And judges will often say that pro se pleadings are construed liberally, but pro se litigants must follow the federal rules. That sentence alone will get your attention. State versus federal, the big difference. State court in general has more discretion, more informal motion practice, longer timelines, more tolerance for procedural errors, whereas federal court has shorter deadlines, automatic waivers, mandatory disclosures, and judge-enforced rules strictly. The clerks reject filings quickly. In federal court, procedure often decides the case before facts ever matter. Federal Rule of Civil Procedure rules that every pro se plaintiff must know. The Rule 8 pleading standard. Using short, plain statements when you're writing your briefs. Must allege jurisdiction, plausible claim, and facts, not conclusions. Common pro se mistakes, or they violated the law with no factual support. Rule 12b-6, motions to dismiss. Defendants almost always file one. Pro se plaintiffs must respond on time, address each ground, and not rely on emotion or fairness. If you don't beat Rule 12, you'll never reach discovery. Rule 4, service of process. This is huge for pro se plaintiffs. That must be done correctly, it must be done on time, and proof must be filed. Common mistake, mailing the complaint yourself to the wrong address, or not using personal process service. That alone gets cases dismissed. Rule 16, scheduling orders. This is where many pro se cases die. Deadlines or court orders, missing them equals sanctions or dismissal, and no extensions without permission. Rule 26, disclosures and discovery. This is foreign territory for many pro se litigants. Initial disclosures are mandatory, discovery scope is limited, and failure to comply can kill claims. Rule 56, which is your summary judgment. This is the real end game. Evidence is required, affidavits must be proper, and exhibits must be authenticated. Summary judgment is about proof, not belief. The biggest federal pro se traps. Trap 1 is missing the response deadlines. Many federal deadlines are either 14 or 21 days. Courts do not chase litigants. Trap 2 is filing letters instead of motions. Federal judges almost never accept letters. Trap 3, not reading the local federal rules. Every district has your local civil rules, standing orders, individual judges' rules. Federal Rule of Civil Procedure plus local rules equals law. A special warning for pro se plaintiffs. Federal judges expect more from pro se plaintiffs than pro se defendants. Why? Because plaintiff chooses the forum. Plaintiff controls service, and the plaintiff, of course, bears the burden. That is why the Federal Rule of Civil Procedure compliance is non-negotiable. So some practical advice before filing in federal court. You want to read Rules 4, 8, 12, 16, 26, and 56. Read the district local rules. Read the judge's individual practices. And after filing, you want to calendar every deadline immediately. Never assume extensions. File motions, not letters. Ask for leave before missing deadlines. In state court, rules can slow you down, but in federal court, rules can end your case. Okay, the rule stack. Most pro se don't know this. Use this simple hierarchy side. Constitution, statutes, federal rules of civil procedure, local rules of the court, judges' individual practice or standing orders. Local rules are not optional and not suggestions. Judges enforce them strictly, even against pro se parties. So, why do local rules matter so much? What are the real consequences? A perfect legal argument can be stricken, ignored, denied as procedurally improper simply because page limits were exceeded. A reply was filed without permission. A letter was used instead of a motion. A certificate was missing. These are not theoretical. It happens every day. Core local rules every pro se plaintiff must know. We're going to use the Middle District of Florida as an example. Local Rule 3.01 motions. What most pro se do wrong. Motions must include legal memorandum. Under the Local Rule 301B, a motion must include relief requested, basis for relief, and legal memorandum. That means case law, guys. Max 25-page total, excluding attachments. Filing a motion with no law equals procedurally defective under the local rules. Response deadlines change by motion type. Under the Local Rule 301D, the standard motion is 14 days. Motion to dismiss, 21 days. If you miss the deadline, the motion may be treated as unopposed. This is the silent killer in pro se cases. No reply as of right. Under Rule 301E, no reply briefs are allowed unless it's summary judgment or you get leave of court first. Filing a reply without permission can get it stricken, ignored, or used against credibility. Local Rule 3.01, no letters to the judge. This is gold for foreclosure defendants. A party must not use a letter, email, or the like to request relief. Under local rules, judges see letters as improper ex parte communication, rule violations, even if polite and factual. The proper vehicle is a motion or a notice of supplemental authority. Court-ordered status report. Formatting rules that can sink a filing. The formatting must include correct margins of an inch, approved fonts, which is usually Times New Roman 14, double spacing, page numbering rules. Judges absolutely notice this, especially in foreclosure and pro se cases. Now look at this table here. You see the issue is motion to dismiss response. And it says the Federal Rule of Civil Procedure. It's under Local Rule 12. And it says 21 days under 3.01D. Reply briefs under the Federal Rule of Civil Procedure are allowed by default. However, they are not allowed without leave in the local rules in Florida. Letters to the judge, it says, are silent under the Federal Rule of Civil Procedure, but are prohibited in the local rule in Florida. Page limits are not specific according to Federal Rule of Civil Procedure, but have strict limits in the local rule. Formatting rules are general under the Federal Rule of Civil Procedure, but in the local rule is very specific. So you want to make sure you follow those rules. Before filing any motion, read the Federal Rules of Civil Procedure, read the local rule chapter on motions, check the judge's standing orders, confirm page limits, response deadlines, whether replies are allowed, whether a memorandum is required. A best pro se habit would be to open the local rules in your PDF before you even open Word. And as far as foreclosure litigation goes, why foreclosure cases are unforgiving. They have high volume dockets. Judges rely on procedural filtering. Banks know the rules, pro se don't usually. Local rules become a weapon if you don't know how to use them, and shield you if you do. Most foreclosure cases aren't lost on the law, they're lost on the rules. Okay guys, I hope this was informative to a lot of y'all, and if you have any questions or comments, you can leave them below. If you're in foreclosure and you have questions, you can send me an email. My email address is foreclosurehelp777@gmail.com with the number 4. And as always, everyone have a blessed day.